Good day, Crime Talk aficionados. This is Scott Reisch with Crime Talk. Thanks for watching. Let's get straight to the docket. First, Ghislaine Maxwell finds out where she'll be residing until her trial date. Second, Dustin Dennis, the Oklahoma dad who is charged with the death of his 2 children, his case was just dismissed. Wait till you hear why. Third, the Supreme Court authorizes federal executions to resume. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch with Crime Talk. Thanks for watching. If you haven't already done so, I would ask that you hit that subscribe button, hit that little bell so that you receive notifications of when we go live, and leave us a comment and hit that like button. First on the docket, Ghislaine Maxwell. That's right. Miss Maxwell is the former boyfriend, confidant, and procurer of underage girls for the benefit of Jeffrey Epstein, allegedly. Now, she was arrested last week, finally brought to New York. She had her arraignment and detention hearing today. Arraignment, that's where you enter a plea of not guilty. The detention hearing, that's where the prosecution can let the court know whether they're going to seek detention or not, and whether the defense will consent to that. Now, sometimes, depending on the nature of the crime, there is what they refer to as a rebuttable presumption, which means that it's presumed that the defendant is a flight risk and a danger to the community. Not so with the charges against Miss Maxwell. However, she does face up to 35 years in prison, and being 58 years old right now would not be a good place to spend the golden years for sure. Now, the United States attorneys argued that Miss Maxwell is a danger to the community and a flight risk. Obviously, the charges of themselves are concerning to the point because the charges carry the penalty of up to 35 years. The United States attorneys obviously argued that Miss Maxwell was a danger to the community and a flight risk. What makes one a danger to the community? Are they out going to commit new crime? As far as we know, Miss Maxwell has no other criminal history whatsoever. The alleged conduct took place over a course of time, which would certainly indicate that one has a proclivity to committing these acts, allegedly. Now, also, the United States attorney argued that Miss Maxwell was a flight risk. This was the strongest argument for the government in this particular case, because Miss Maxwell is a United States citizen and has joint citizenship from England as well as France. What the United States attorneys were concerned about was the fact that if Miss Maxwell were to be given bond, that she could make her way to France, whereby a French citizen would not be extradited back to the United States for trial. The defense would argue that Miss Maxwell was not a danger to the community. Why, you say? Because she is presumed innocent. These are mere allegations against her, and that presumption of innocence remains with her until and if the prosecution can prove their case beyond a reasonable doubt. Additionally, Miss Maxwell offered to put up $5 million in property for collateral. Some of the property was in the United States that was being offered by the defense, and some of it was out of the country. The United States attorneys argued that anything outside of the country was worthless, and there's no way that they could ever collect on it if she were to run. So it would basically amount to an unsecured bond, and it meant nothing that would secure her appearance here for trial. Now, I saw several commentators that said, ooh, this could be a close call for Miss Maxwell. Ooh, I don't know what the judge will do. Yeah, didn't see this as a hard decision at all. You have to remember, when Miss Maxwell was located, she attempted to flee when she realized that the FBI was coming to get her. Now, she wasn't able to make it out of the house, but it's not like she greeted the FBI at the front door. She ran and attempted to barricade herself in another room. She was taking steps to evade detection. Her counsel says it was simply for the mere fact that she was afraid of the public, i.e. people that want to harm her, as well as staying away from the news media who were essentially stalking her. But the reality of it is she was pretty good at evading being located. It took time for the feds to find her and locate her. And she was also taking some very crude and probably worthless attempts to hide her cell phone location by wrapping it in aluminum foil. We know that Ms. Maxwell recently purchased the home in New Hampshire with a friend who was also one of her bodyguards, and she used a false identity when purchasing that home. She actually held herself out as a journalist and went by several aliases. These are all factors that the court would consider, and frankly, this was not a close call. The judge denied Ms. Maxwell a bond, and she will remain in custody for her jury trial, which is currently scheduled for July 12th, 2021. That trial is set to last some 3 weeks. Now, you may say, Scott, I thought I heard you say in the federal system, when one remains in custody, they, being the government, only has 70 days to get the defendant to trial. Well, yes, you are correct. That is true. But in this particular situation, the defense on the case and 2 of her attorneys are new, need time to adequately prepare. There is apparently large number of documents that need to be reviewed, as well as I hear there's a couple of videotapes that may have some embarrassing circumstances for lots of people in positions of power. That is going to take time for the attorneys to go through that and prepare. So in light of the voluminous discovery, the court granted a continuance based upon the complexity of the case. So based upon the amount of discovery, the court granted a motion to declare the case complex so that it allows the defense adequate time to review, analyze, engage in motions practice, and be prepared for trial. Now the big job becomes the Bureau of Prisons to keep Miss Maxwell safe. Obviously, we know that Mr. Epstein died while in custody. Apparently, Miss Maxwell is getting the VIP treatment. She apparently is moving cells every day. When she is out of her cell, she's being guarded all the time so that other inmates will do no harm to Miss Maxwell. Today is the official day 12 of the Miss Maxwell Suicide Watch. We'll see if she can make it until July 12th of 2021. Let me know in the comments below whether you think she's going to make it. I'm asking you to go to CrimeTalkSearch.com and sign up for the subscription offer that we have for you for background checks. That's right. You can, for a small fee that you can cancel anytime, search as many people as you want anonymously and find out, and a report will be prepared while you wait, and you will receive information related to social media information, emails, telephone numbers, criminal background checks, bankruptcies, property records, marital records, everything that you would want to know about if you were going to be involved, whether in business or in a personal relationship with an individual. Go to CrimeTalkSearch.com, sign up for your subscription. You'll be happy you did. Next on the docket, Dustin Dennis. We talked about him yesterday, as you may recall. So Mr. Dennis was arrested several weeks ago based on the fact that his 2 children passed away in his truck parked outside of his residence. It was alleged that Mr. Dennis had taken his 2 children in the truck to a quick stop to get a few items at the store. Upon his return, the children went into the home with him. Mr. Dennis took a nap. He woke up some 4 hours later, could not find the children, ultimately found them passed away in the truck due to the heat. The police were called. Mr. Dennis was immediately arrested. He was given a PR bond by the state court when video surveillance from a neighbor's camera revealed that the children left the home on their own, got into the vehicle, and never came out. Mr. Dennis was charged last Friday with 2 counts of second-degree murder related to the children. Mr. Dennis was also taken back into custody based upon the nature of the charges. Well, today, the district attorney in Tulsa dismissed all charges against Mr. Dennis. And you may say, did the district attorney think, oh my gosh, Mr. Dennis has suffered enough? Oh my goodness, this is a tragedy. The victim does not want the father of the children punished any further? No, that's not the case. The reason why the district attorney had to dismiss the case was a case based upon a Supreme Court of the United States ruling last week called McGirt versus Oklahoma. Now, for some of you who may have heard about this particular case, it involves a case of jurisdiction. And what do we know about jurisdiction? That's right. It can be raised at any time. Well, the case of Mr. McGirt, he was charged in state court as it related to some very inappropriate charges involving some sexual offenses. He lost a trial, he appealed, but throughout the process, he stated that he, as a member of a Native American tribe, that he could not be charged in state court. And he was citing various treaties and documents going back to the time when various Indian tribes were moved from the east coast of the United States to what is now Oklahoma. And through these documents, the United States government made various promises. And some of the promises that were made were kept, and some were not. And one of the things that took place was there's a thing called the Major Crimes Act, and it provides that within the, quote, Indian country, any Indian who commits certain enumerated offenses shall be subject to the same law and penalties as all other persons committing any of those offenses within the exclusive jurisdiction of the United States. Indian country includes all land within the limits of the Indian reservations under the jurisdiction of the United States. And like I said, Mr. McGirt was convicted in state court of these serious charges, but he was a member of the Seminole Nation, and his crimes allegedly took place on the Creek Reservation, and he sought a new trial basically saying, I have to be tried in federal court. Well, guess what? This could create a lot of havoc. And the Supreme Court knew that in what they call a plurality decision, a 5-4 decision. Justice Neil Gorsuch wrote the opinion, and when he was a 10th Circuit Court of Appeals judge, ruled oftentimes in favor of the Indian nations based upon the plain language of the words in the treaty or the lack thereof, which is what we refer to as an originalist. You view the documents at the time that they were written and give them the plain meaning effect as they meant at that time. So Judge Gorsuch turned the more liberal justices in the McGirt case into originalists and turned the more conservative Supreme Court justices, who are usually saying this is what the law is, this is what it says, you can't change the meaning, saying you can't do this, it's going to create havoc, and basically legislating from the bench and amending the documents as written, even though everybody knows that would have been an intellectually dishonest outcome. So Supreme Court said on a 5-4 decision, don't care what happens, let the chips fall where they may. The government could have made these Indian lands subject to state jurisdiction, but they never got around to it on the Creek Nation. And therefore, when you hear headlines saying that half of eastern Oklahoma, including Tulsa, where Mr. Dennis resides, is subject to Indian law, that's in fact the case. The district attorney is stating in this particular case that the mother of the victims, Ryan and Tegan, are all members of the Cherokee Nation. Apparently, mom has an Indian card, Tegan has an Indian card, and Ryan was in the process of getting an Indian card. So the district attorney is stating it's clear that the jurisdiction lies with the federal government, and they dismissed the prosecution in state court and referred the matter to the United States Attorney's Office. So this was the important reason in the dissent in the McGirt case was they said, now the United States Attorney's Office, who usually doesn't get involved in everyday crime, they usually are involved in more of the federal offenses, obviously, guns crossing state lines, narcotics crossing state lines. Now they have to prosecute basically everyday crime in Tulsa if a participant or a victim of the crime is a Native American Indian. The United States Attorney is not necessarily geared up for this, and the United States Attorney had no comment when asked by the press today how they proposed to proceed. And so If you all would like a little light reading about the history of the Crete nation, you can look up the Supreme Court opinion. It's only about 46 pages for the majority opinion, and then the dissents are about another 70-some pages. Little light reading. It's what I do to go to sleep at night. But for now, Mr. Dennis is a free man. Let me know what you think. It's been said that the law is reason removed from emotion. Clearly, the Supreme Court knew this was going to be a problem in Oklahoma. So now all defendants who are either been prosecuted and convicted are being prosecuted and convicted, and anyone who gets charged in the future who is a member of an Indian nation will have to be charged in federal court. And all those people that have been convicted of serious offenses now, years later, can get a new trial. Do you think the Supreme Court made the right decision? Do you think it was right in this particular case as it relates to Mr. Dennis? Let me know. In more news from the Supreme Court, last night, after a flurry of last-minute filings, a divided Supreme Court cleared the way for federal executions to resume for the first time in nearly 20 years. There's been a huge battle going on for literally the last 20 years, and specifically the last few months, about the protocol that was used for lethal injection to execute federal inmates on death row. Lower courts have been stopping the proceedings, and the Supreme Court has either been not getting involved or ignoring it. The case that was at issue was the matter of Daniel Lee. He was at a federal prison in Indiana and was executed shortly after 8 a.m. this morning. Now, Lee was on death row for a 1996 murder of William and Nancy Mueller and Nancy's daughter, 8-year-old Sarah Powell. After stealing approximately $50,000 worth of cash, guns, and ammunition from the Muellers to fund a white supremacist movement, Lee and his accomplice shot the Muellers with a stun gun, placed plastic bags over their heads, and threw them into the bayou. However, Ghislaine Peterson, the mother of Nancy Mueller, didn't want Mr. Lee executed, but if he was going to be executed, she wanted to be there. And on July 10th, a federal district court judge in Indiana put the execution on hold so that Ghislaine Peterson could in fact be present. She's 80 years old. However, she wanted to be there to attend the execution, but wanted it postponed due to the COVID-19 pandemic, which would put her health at risk. Ms. Peterson actually filed motions with the court asking for the stay so that she could in fact be present. Lee also filed several last-minute petitions arguing that lethal injection is cruel and unusual punishment and that he in fact could feel pain. And we talked about it, I think it was late last summer, a case that came out of Mississippi where the Supreme Court said you basically are not entitled to a painless execution. So, how about a little bit more good news out there, everybody? That doesn't cheer you up. Let's talk about something near and dear to everyone's heart and should be near and dear to everyone's heart, and that is their own personal safety. All right? Think about it. What do buildings have to let people know that a building has been broken into? An alarm. What do cars have to prevent people from breaking into their car? An alarm. Why? Because they're noisy. They draw attention. And what do we know about criminals, ladies and gentlemen? They don't want to be identified. Well, you can have your own personal alarm system here. All right? Go to Crime Talk Offers and get your own personal safety siren. This thing is perfect for your car, your home, your purse, your pocket, your backpack, anywhere you need it for your own protection. And I'm telling you, this thing works. It stays securely. Let me tell you, this thing works. You put it on a keychain. You put it on a backpack, on a zipper. If there's an emergency, you keep it in your pocket, whatever you need to do. But when something happens, you don't feel secure, you think something's not right, you think that won't get the attention of people? It certainly will. Do you think that'll make the bad guy turn around and go away? Absolutely. Go to CrimeTalkOffers.com and get your safety siren today. You'll be glad you did. Next on the docket, our dumb criminal contestant of the day. Our dumb criminal contestant of the day comes from Pennsylvania, who was arrested after she flung a knife at her boyfriend, striking him because she was angry that he refused to eat. That's right. You could just say, if you're not going to eat your dinner, you're going to go to bed hungry. You're not going to get any dessert. But throwing a knife is probably not one of the better options available to you. According to police reports, officers arrived around 3 p.m. at the home of Danielle Barbacow. She's 26. And in one of the rooms in the house, they found her boyfriend, who was using a belt as a tourniquet around his right leg to stop the bleeding. Barbacow allegedly told police she got angry because she wanted him to eat and she threw the knife, quote, out of reflex, unquote. Now, the victim in this particular case allegedly claimed that he was cutting jalapenos and that he possibly slipped. The police thought that that was impossible because the knife was stuck in an upward direction. Ultimately, the boyfriend admitted that they had in fact been arguing and was taken to the hospital for treatment. Ms. Barbacow, on the other hand, is charged with aggravated and simple assault and possessing an instrument of crimes. Ms. Barbacow, you are a dumb criminal contestant of the day. Just send them to bed with no dessert if they're not going to eat your dinner. You probably put a lot of time and effort into that meal, and the least he could do was act like he was hungry. But for that, Ms. Barbacow, you are a dumb criminal contestant of the day, who could ultimately be the dumb criminal contestant of the week if you're that lucky. Now, tonight, we are going live 6 p.m. Mountain Time on YouTube as well as Facebook. Be there. We will answer your questions, and we will also go to our Patreon members right after that for any questions that they want to ask, as well as any cases that they want to discuss. So we'll see you tonight, 6 p.m. Mountain Time for Crime Talk Live.